This passage was on the law and economics, and it said that the law and economics approach worked for the powerful, and it believed in competition in the market. So let's look at the passage a little more in detail. This was a difficult passage. Now, normally when you get a difficult passage, and if that is the first one in the test, what do? One approach many students take is to read it in 25-30 seconds, realize this is very tough, do passages 2, 3 and 4 and then come back to the first one. Fine. I would actually read the passage quickly and answer whatever questions I can answer and move on to the second, third, fourth passage and the para-jumbles. Otherwise, in many cases, you won't have time to get back to the first passage, and the last 5 minutes to 7 minutes of the test anyway cannot be used for answering reading comprehension passages, especially not the last 5 passages, because nothing you'll read will make sense. Alright, but that is my approach. Your approach may be a little different. The genius of law and economics, whose influence in legal institutions became really ascendant in the 1970s, was to resuscitate the key elements of the Lochner era approach, but to clothe them in connection to a supposedly objective and neutral social science. Reading these 4 lines, many students say, let me move on to the second passage, which is fine. You have not spent too much time. So basically, he said the law and economics approach, the influence of this approach started in and became more and more powerful in the 1970s. What it did was take the main elements of the Lochner era approach. Now, you don't know what's the Lochner era approach. This passage wouldn't even expect you to know it, because we only bothered about the law and economics approach and not the Lochner era approach. And whatever it has taken, it has been derived from the Lochner era approach. So you can draw a few conclusions about draw a few inferences about the Lochner era approach based on what has been given here. More than that, don't let it bother you. Your lack of knowledge of the Lochner era approach, don't let it bother you. But when you have time after the test, do look it up. It increases your knowledge, and also it will help you feel better next time you come across that expression. So what did it do? It took certain elements of the Lochner era approach, clothed it, covered it, made it look different, packed it in connection to a supposedly objective and neutral social science. So they took these elements and they said, this is neutral and objective social science, whatever the approach, the rules they gave, rather than to a particular political and moral vision. They said, look, so basically, let me tell you that the Lochner era approach, the Supreme Court, the court used to strike off a lot of economic policies saying this is not right. And so it decided which economic policies were good. So here what did it do? It said, listen, we are not being guided by any political or moral vision. We are neutral, and based on our neutrality, we have chosen certain elements of law and economics, which is good for the society. The law and economics approach obscured its own activism on behalf of the powerful. It said it's neutral, and in this way it covered up its leaning towards the powerful. So what's the author saying here? Simplify it in your own words, that the law and economics approach was actively doing things, was bringing about changes, but made it look as if it's neutral, while it actually worked on behalf of the powerful. Clear? The political projects of dismantling public rights over markets, diminishing working people's influence by attacking unions, delegitimizing the social provisions of the welfare state, all drew upon the law and economics movement. So what can you infer from here? The law and economics movement, its rules were such that it managed to do all this. It dismantled public rights in favor of markets. So markets took precedence. Second, it diminished working people's influence by attacking unions. It delegitimized social provisions of the welfare state. All this it did. All this was done under this so-called approach, using this so-called approach. Following neoclassical economic theory, law and economics suggested that society's resources are best allocated by permitting competition to set prices. So what was its first principle? Society's resources are best allocated when you allow the competition to set prices. Competition was what its focus was. Market ordering through legislatures or workers' organizations interferes with this optimal natural process. Competition is the natural process supported by this approach, and it said that allowing legislatures and worker organizations to order market was against this natural process. So they were in favor of competition. They were against intervention through legislature or working organizations through ordering markets. They said, let competition take over the structure of the market. Few other social scientists believe this. Now, this approach that competition should be given a free rein, legislatures and workers' unions should not order markets, this approach found very few supporters among social scientists, and growing number of economists do not believe it either. So it did not get the approach. Social scientists don't support it, and nor do economists. The ideology of law and economics revolves around the concept of competition. Now remember, the earlier paragraph we read competition, again this competition is there. So that is a point you cannot miss, right? The ideology of law and economics revolves around the concept of competition. It suggests to the world that this is the main value it seeks to promote, thus also seeking to limit governmental intervention with that process. So the ideology of this law and economics approach was competition. It therefore told the world that, look, this is the main value that we are seeking to promote. We are seeking to promote competition, and therefore, since we are seeking to promote competition, we are seeking to limit governmental intervention in competition, in that process of competition. Now, the author says, but remember, I've told you many times, when you come across this word but competition does not take place in a vacuum. It always requires rules, from property to contracts to antitrust, that are themselves, logically speaking, limits upon competition. So whenever we talk of competition, competition works only when there are rules about the competition. So these rules by default seek to limit competition. They are the limits. The rules are the limits upon competition. The competition works in the framework, inside the framework of these rules, right? All of these rules, in essence, authorize economic coordination that is necessary to make competition work. So for competition to work, there should be economic coordination, and economic coordination happens through rules. For example, see how beautifully he is building the argument. For example, property rights authorize control over economic activity to the extent of their bounds. A contract too is a form of economic coordination. Now he's telling you how economic coordination is what allows competition to function. And this economic coordination also requires rules. All right. Next, competition law itself authorizes all kinds of infirm economic coordination that it prohibits out of firm. So when we're talking of competition sets certain rules which allows infirm coordination. Inside a company, there is economic coordination. Let's do this. So this is what it does. But the same things it will not allow you outside the firm. In short, now this is summing up whatever the argument is leading up to. This is what you need to remember. Government intervention all the way down. Who sets the rules? Who sets the rules of what is permitted inside the firm, in firm, but not permitted out of the firm? All these rules is nothing but governmental intervention. The law from the outset from the beginning, law makes choices about where and how it will limit competition. And those choices can either balance economic power or create imbalances. So what is the role of law in competition? It's all right. Economics and law approach says give competition a free rein, limit governmental intervention. The author says, but for competition to function, you need economic coordination, you need rules which limit. So competition only works under a set of rules. Therefore, he says, the law from the beginning makes those choices. Where is competition allowed? In what form will it be allowed? How will competition be limited? Everything is set down in the rules. And those choices, those rules, those choices it makes about where and how to limit competition, they result either in balancing economic power in the society or in creating imbalances. Depending on the nature of limits you are and rules you are putting in, the nature of the society will change, whether it creates a balance in the economic power in society or creates imbalances. The ideology of law and economics is that only interventions that help to balance power in society are in fact governmental interventions. So this approach says that only interventions that balance power in society are the governmental. There are different kinds of intervention, but those interventions which help to balance power are in fact the governmental interventions. But that is not true. That is what the economics and law approach claims. But the author says that is not true. You cannot say that only interventions which help to balance power are the governmental institutions. That statement is not true. All right, next. These issues, now he's talked about the state of things. Now comes to the debate at present on this. He says these issues are resurfacing today in public discussion about competition law. So there is a lot of public discussion about competition law, which is also known as antitrust law in the US, which is the area of law perhaps most colonized by law and economics. So what's he saying? Law and economics has set rules everywhere. But the one area where it has totally taken over, totally colonized, is in the area of competition law. All right? And there is a lot of public debate on that now. What does it say? Public debates have centered around economic power and the role of law in it, with renewed calls for the law to do more to ameliorate economic domination rather than exacerbate it. So what are the people who are engaged in this debate saying? They are saying that the law should lessen economic domination. Society is dominated by a few companies, by a few people. There's economic domination of a section over another. And the author has earlier argued that this is because of the kind of competition law that exists. So public debate, the public is making calls that, look, you should have laws which will balance this, which will lessen economic domination rather than exacerbate it, aggravate it, increase it. Defenders of the status quo, those who are happy with the way things are going right now, defenders of the status quo regularly point to economics as a defense. They say, this is what economics is. How can you change it? They suggest that only the reformers have a moral and political vision. They say, why are you asking for this? The reformers have a moral and political vision because of which economics is working this way. But of course, that also isn't true. So the author has earlier countered the balance of economic power through governmental interventions. He says that's not true. That claim is not true. Second claim that he says is not true is only the reformers have a political and moral vision, and this economic domination is just a result of pure economics. He says that's not true. How does he counter that? Just as law and economics does generally, the current framework of antitrust law chooses certain legal rules over others and takes them to define the market. So now, when you look at competition law, he says the same thing has happened. The law and economics approach, it chooses certain rules over others. It says, this should be the rule. And it picks and chooses the rules on competition that it wants to put in place. Competition law makes the affirmative decision to organize economic coordination primarily through traditional capitalist firms. So competition law also makes this conscious effort and decision to organize economic coordination. It does organize economic coordination. That's how competition works. But this economic coordination, it does through traditional capitalist firms rather than through alternative firms. So it's doing this through traditional capitalist firms. It's not choosing alternative firms. What are those alternative firms? Let's see. These alternatives might include looser forms of producer associations that are more dispersed in ownership and more democratic in decision making, but the current competition law does not take them into account. It is preferring the traditional capitalist firms. These choices in choosing the laws, in making choices on what defines competition, what defines market, these choices are fundamental to the policy prescriptions made by the law and economics approach. Again, we find ourselves with a choice that is necessarily moral and political. On what basis do you make a choice? On the basis of your moral and political leanings. And we can allocate coordination rights according to those moral and political beliefs that you have. You allocate coordination rights in a way that exacerbates, aggravates, worsens the imbalances in economic power, or in a way that ameliorates them, makes it better, makes it decreases it, lessens it, makes it more bearable. So either the law and economics approach says only the reformers had a moral and political vision. This is just the market which is dominating, which is economics which is determining what is happening. But the author says, no, that's wrong. Whenever you make a choice of what rule to implement, what limits to implement, it's a result of your moral and political vision. You, on the basis of your choices, the result would be either to increase the economic imbalances or to lessen it. Clear? So now the passage suddenly looks easy. Now, when you read it the first time, try to simplify it, summarize it, so you can answer at least half of the questions in the same time. Don't spend too much time, whether it's a difficult passage, moderate or easy passage. You cannot complete all the questions then. And since the parajumbles and parasummary and odd one out are right at the end of the exam, you end up missing a theta question, which is not advisable, not very smart to do. According to the passage, all of the following are true about law and economics approach, except which one? So which one of the statements is not correct according to the passage about what? The law and economics approach. It seeks to minimize government intervention in businesses and markets. It says that we are trying to competition should be given free rein. That means minimizing the government intervention, though the author expresses some other view, but this does aim to do that. Yes, A is correct. So A cannot be my answer. It permits government interventions only in areas that help to balance power in society. Now, this option has all the words that you've read in the passage. Something on government intervention only, balance power in society has been given. But is it exactly what it says? We'll find out. It exacerbates, worsens imbalances in economic power. That's what the author says. That it says that it tries to balance, but actually ends up exacerbating. It has dismantled the welfare state. He gives that as an example in the first paragraph. Now let's look at B, because B seems to be what it has said. Let's go back in the passage and see if B is the right answer or not. Look at this paragraph. The ideology of law and economics is that only interventions that help to balance in power, if there are interventions which help to balance power in economic sense. These are government interventions, but that's not true, the author says. The only interventions that help to balance power in society are in fact government interventions. Okay? So government interventions are the only interventions that seek to balance power in society. So only interventions which seek to balance power are that of the government. That's what he says. But the author says that's not true. This is what he has said. What does the answer option say? It plays with the rules. What does option A mean? What does the passage mean? We know. What does the author mention in the passage? We know. What is said here? It permits government interventions only in areas that helps to balance power in society. Is that what the author said? No. Therefore, that's the wrong answer. That's my correct answer. That is not true about the law and economics approach. This is a common wrong answer that is often given by exam setters. So you have to be very careful. Just because you remember reading only government interventions, balance power, does that make it the right answer? No, the author has twisted the meaning as it is given in the passage. Therefore, that's not the right answer.